Why Supreme Court puts the Sedition Law on hold? What does the Sedition Law say? So Supreme Court of India rendered a historic judgment that they are going to suspend the Sedition Law until the government reviews. So there were many allegations on the Sedition Law that the innocents were falsely booked under the draconian law. So what is the Sedition Law and who brought the Sedition Law? First we can see about it. So the British introduced, they have enacted the Sedition Law in 17th century, and in 1860 British have introduced the IPC, Indian Penal Code, the criminal offence framework in India. After 10 years, in 1870 they have inserted the Sedition Law under section 124A. So Sedition Law is prevails under section 124A from 1870. Even the great leaders like Mahatma Gandhi and also Jawaharlal Nehru, Bhagat Singh are also booked under the draconian law. First we can see what does the Sedition Law say. Sedition Law says that whoever by words, either spoken or written, or by act or by representation, signs criticizing the government, bring hatred towards the government, or strongly criticizing the governmental methods, or government strongly expressing their contempt against the government, they are all booked under the Sedition Law. This was brought by British. So simply we can say anti-governmental views. People who have anti-governmental views can be booked under the Sedition Law. This was brought by the British. After after India got independence, there were many criticisms about the Sedition Law, and many were started protesting against the Sedition Law, and they demanded to scrap the Sedition Law. So if a man booked under Sedition Law, they can get at least 3 years imprisonment, and till sometimes in some cases they can get the life imprisonment, and also they are barred from getting passport, and they are under frequent surveillance. So this will affect the person's liberty. So in 1962 a case happened in Supreme Court of India, Kedarnath versus State of Bihar. So Kedarnath, a communist party, a forward bloc party member was booked under the Sedition Law for criticizing the Congress government. So Supreme Court of India delivered a judgment. They upheld the Sedition Law. They once again told that the Sedition Law is valid, but they have introduced various restrictions that if a man criticizing the government, they have anti-governmental views, they should not be booked under the Sedition Law. But a man who creates public disorder or bringing some sort of violence in the society, so they should be booked under the Sedition Law. Those who have terrorism charges and they bring violence in the society, so those are all should be booked under the Sedition Law. But the anti-governmental views should not be booked under the Sedition Law. So this is a historic judgment in Indian history. Police has the power to book a suspect under the Sedition Law. So and many state governments are misusing the draconian law. So the case came under Supreme Court. So now Supreme Court of India puts the Sedition Law on hold. But the government side, they have argued that in Kedarnath judgment already the court upheld the Sedition Law. So why again Supreme Court is reviewing? But the petitioners told that in Kedarnath case judgment, the Kedarnath challenged the Sedition Law under Article 19, right to freedom of speech and expression. But now the case is booked under. Now they are challenging under Article 21, right to life, and Article 14, right to equality. So now the case must be important, and the Solicitor General Tushar Mehta argued in court that the government wants some time to review the situation. Until then, the court told that the Sedition Law should be suspended, and the suspects who are booked under the Sedition Law can get bail by going to the respective courts, because Sedition Law is a non-bailable offence. So until now 13,000 were booked under the Sedition Law. So those people can get bail by approaching the courts, the respective courts. So now Sedition Law under review, and the central government also raised concerns that many terrorists were booked under the law. So there are many arguments going and revolving around the sedition law. But in my view, sedition law should be scrapped because it is a colonial law, and many governments were misusing, because when people were criticizing or activists are criticizing against the government, the anti-governmental views were suppressed. Anti-governmental views differ from anti-national views. Sedition law is for the anti-national, not for anti-government after Kedarnath judgment. So this is my view. Thank you.